the City Council, and feel free to email any of the council members with ideas or opinions. And we've been getting a lot of emails from people, but actually for these meetings, we're having a hard time keeping it to 2 hours. Our last meeting went over by a half hour. We will be doing a presentation to the City Council on August 18th, and before any kind of zoning recommendations or code changes are made by the City Council and the Planning Commission, there will be public hearings where the public can provide input. We're also, one of our recommendations is that the City Council and the Planning Commission has some public input from developers and present the recommendations that this particular task force came up with. But I hate having people raise their hands and not addressing what they have to say, but we're under a real time constraint, and to try and get through everything we need to in a 2-hour time frame. So I just wanted to mention that to anyone here. We're glad you're here. If you have any comments, you can email to us after the meeting, but we really got to try and get through an awful lot of information and material in a short period of time. At our last meeting, we spent 2.5 hours going over Olathe's and Lee Summit zoning. That was some unfinished business. We had some questions for staff, and we're going to be reviewing that and hopefully come up with some recommendations regarding zoning changes to our current codes. We're going to have 3 guest speakers. We're going to have Mr. McDonald address some questions that this task force had regarding regulating the quantity of multifamily in Blue Springs. Right. Also, if we do make any kind of recommendations regarding code changes or changes to our UDC, at what point in time it will take place during the development process. So he's going to address those 2 questions for us today. And then Tom Williams with Ingalls Williams Management is going to present some ideas he had for architectural and design standards. And Phil Perry from the Home Builders Association also is going to present, oh, Mr. Perry, he is going to present. So we were going to do the first hour with our guest speakers so that they could stay and listen if they like, or they could get on their way if they want to leave. And then the second hour we're going to work on our unfinished business regarding the multifamily zoning codes, and if time permits, then Scott Allen was going to do a presentation on the design standards in our new downtown zoning. If not, we'll go ahead and put that for our next meeting. With that being said, I'm going to turn this over to our city attorney, Mr. McDonald, to answer some of the questions that we had as a committee.
You want me here?
You just stand anywhere you please.
Well, basically, what I was asked to talk about was the legalities involved in regulating multifamily, which specifically deals with the issue of exclusionary zoning. The packets that I've given you have the agenda, which we will go through tonight. Second thing is a multifamily FAQ that just has a lot of little excerpts of things that I picked up while I was looking over this issue. I then have a set of the multifamily present standards that we use in there for you. I then have some actual legal law type stuff that deal with exclusionary zoning and things such as that are sort of the basis of the talk. The moratorium ordinance, of course, defines multifamily as any use of a site for 3 or more dwelling units within a single building, as defined in Section 411.020 of the Unified Development Code. The moratorium ordinance is going to expire in August if it's not renewed. Whether it expires on the 18th or the 19th, depending on how you treat midnight, it's that date. The present codes that we have that regulate multifamily involve Section 405.020, which are special use standards for multifamily. And that special use standards group of ordinances which are attached includes the requirement that you go through site plan and design review. So multifamily units must go through site plan and design review also. Let's talk about the regulation of multifamily itself. I mentioned exclusionary zoning. That is where a court finds that you have excluded certain people, the ones that are predominantly looked at in this day and age are low-income people, trying to exclude low-income people, or effectively excluding them because of the situation in the country. If you're excluding low income, you are usually impacting racial minorities also. So what the courts are looking for are regulations that illegally exclude low income and racial minorities. Basically, there are a few states that have fair housing laws and operate under fair share requirements, which specifically by state law require municipalities to provide low-income type housing, or at least provide property that is zoned such that low-income housing can exist. New Jersey is one of them. Pennsylvania is one of them. If you look at cases from those two states, they're operating under different rules than we are in Missouri, where we don't have specific laws in that regard. Basically, the United States Supreme Court in the Arlington Heights case, which is cited in the literature, decided that you had to actually prove discriminatory motive in order to overturn a zoning ordinance that was being challenged on the basis of discriminating against low income or racial discrimination. That sometimes is very hard. Ordinances are presumed to be valid. They really have to find something that indicates or proves that there was a discriminatory motive. For that reason, it's very important that this body is careful in why they're doing things and what the reasons are they're doing what they're doing, so that there's no indication that the motive has anything to do with race or low income. The reasons for zoning legislation, formulation of the reasons for your zoning changes in multifamily are probably the most important thing that you need to look at. It's best if you have a reason that's probably been approved by courts. Some of the things that have been approved are to control municipal growth consistent with availability of municipal services. In other words, you don't have the municipal services, you have to allow a project to come in because you're a small town or whatever. Preserving small town character and precluding uncontrolled and rapid growth. There's been a case where they were allowed to just use multifamily as a buffer between single family and commercial, and their regulations you had to be between, or you couldn't put in multifamily, and that was approved. Preservation of 5-family neighborhoods was approved as a valid reason in the California case, the Belterra Woods case. The preservation of a rural environment was approved in Los Altos Hills, and to reserve its small town character, its open spaces, and low density of population, and to grow at an orderly and deliberate pace was approved in the Petaluma case. There are many different ways of regulating multifamily, and it's hard to just say that one is allowed and one isn't, because the strongest issue is whether or not it was improperly motivated. If it can be anything, if it was motivated to exclude minorities or low-income people, it's wrong. So the first issue is being sure that you have a goal that is not improper, it's not discriminatory. But some of the things that have been approved or have been used, I shouldn't say necessarily always approved, is to mandate residential density that is so low that it doesn't support a lot of multifamily, restrict land areas zoned for multifamily, or attach housing to an insignificant share of the total land area. In other words, limit where you allow it to go. In the Petaluma case, they allowed the limitation of the number of multifamily or attached units that may be built in a year based on the idea of controlled growth. One of the questions that I was specifically asked was ratios, what has been